All right, so let me do this, and let me do, here it is. Okay. All right, so this is going to be our last writing weekend. How exciting for everybody. We're almost done. Besides your homicide report. So this week, if you haven't had a chance to take a look at the writing assignment, it's nothing that you haven't done, but it's just a little bit different in the sense that this is the domestic violence video. And what I'm really looking for is having you take a look at the 3 different crimes that are listed, and then you decide which one fits, or if any of them fit. I'm pretty sure one of them will fit. At least that's the way that this is supposed to work. So, and maybe you may even come up with more than one. But I have the link to each section, and part of this kind of learning lesson here is for you to understand the elements of crimes and how they fit with your report, and to make sure that you can write your report that covers the elements of the crimes. And then at the end of the day, remember, in our chapter that we're going to talk about tonight, talks about kind of wrapping it all up, which means taking your case to court. So after you've done the investigation, you've made the arrest, or at least written the report, if it goes to court, now what? And then I also put in this week's writing assignment, just so you know, there are a lot of policies, especially when it comes to domestic violence. So I stuck in Rialto's policy. It's probably been updated since I've been gone, but this was the last version of it. So if you want to see how long the policies are on certain things, especially something like domestic violence, you'll find out how detailed it is and how many other little steps that you have to take in order to do one of these types of investigations. So you're going to need the face page, the incident crime report, probably all 4 pages of it. Investigate it like you would any other crime. You have 3 different sections to look at to see what fits and how you can write your report to fit the elements of that particular crime, whichever one you decide to pick. And then the narrative. So nothing super different other than kind of testing you a little bit on reading a criminal code section and figuring out after watching the video what really fits within that particular crime set. And if you have any questions while you're going through it this week, just shoot me an email and let me know, and I will get right back to you. I'm usually pretty prompt. But our lecture is going to cover Chapter 16. Let me get all the way to the front. Okay. So, and they titled it Putting It All Together. So it's kind of, it's the end. What happens now that we've done all this writing and interviewing and note-taking and everything else, and we're going to kind of put it all together, and hopefully whatever we have submitted is going to be enough to be able to get a case filing. Don't get stressed if your reports don't generate a case filing, because sometimes maybe there's not enough information in there and you need to do another interview, or maybe the district attorney wants another statement from somebody, or maybe you need better pictures. Whatever it is, it doesn't mean that your report was bad. It just means that perhaps you need a little bit more investigative effort or something else to help meet the elements of the crime before the DA is actually going to file the case. So there is a big difference, understand, between you making the arrest because you have probable cause to make the arrest, and the DA looking at your report and making sure everything is there to get a case filing. So what we want to kind of learn tonight is to be able to understand. We've already looked at a lot of different forms, so we're not going to kind of go back and hash those. But we are going to kind of go through a little checklist and talk a little bit about testimony and body language and what happens with your report, etc. So that's kind of where we're going to go tonight. The big key to success for courtroom stuff, anything, really is how you prepare. And kind of think of it like an interview for a job interview. If you don't prepare for that interview, chances are, unless you're just really good like that and you can operate that way and you're fast on your feet and you can think and all that other stuff, you might do okay. But the more you prepare, the better off you're going to be. So really, your best reference that you have for preparation is going to be you reviewing your report. Maybe a couple of other officers' reports, but all of those pages, as we've learned, those supplementals and things like that, they're all going to get attached to that main report. And so typically officers, a day or so in advance of the court hearing, they'll get a copy of their report from records or whoever they need to get it from, and they'll review it. Not really to memorize it, but just to kind of refresh their memory. And also remember, it does say, yeah, you need to know your case, but you are allowed to bring that report with you to court. You can have it with you up on the stand. You can't really read from it, but you can use it to refresh your recollection. So, and we'll talk a little bit more about when you get questioned about something, not trying to guess. That's really, you really don't want to guess. When you're up there on the stand, if you don't know something, that's what you tell them. I don't know. And then the attorney typically will ask, well, if you looked at your report, would that help refresh your memory? You could say yes, then you could read it, and then you could go ahead and testify from there. So you are allowed to bring a copy of your report with you to court. Again, making sure that your report has all the key elements. Think about the evidence. We've talked about that a little bit before. The facts that really prove your case. More than likely, what's going to be, I wouldn't say attacked, but picked at, is going to be the way that you either interview or the way that you collected your evidence. Those are typically a couple of angles that a lot of the district attorneys or defense attorneys will go after. How you collected, your evidence. What did you do with it? Was there a chain of custody like we've talked about before? How was it packaged? Was it contaminated? All of those little things. So, start thinking about, your evidence in the case. And sometimes you may even have to bring some of that evidence to court with you. And we'll talk a little bit about that. Always review your state's statutes regarding the elements of your crime. Because again, you don't have to prove every element to make an arrest. You just need probable cause. But if you want to get a case filed and a conviction, you're going to have to meet the elements of everything in there. Otherwise, you're not going to win. And we talked about elements when we looked at different statutes like robbery and burglary. There's certain, burglary takes a specific intent to go into a place to commit a felony or a petty theft or a grand theft. And again, so you have to read the section so you know. So that's kind of why I gave you 3 choices on your writing assignment, 3 different sections to look at, because each one has a different little element to it. So I want to see how good you are at being able to pick that out. So again, you can bring a copy of your report to court, but always review it. Don't just bring it and hold on to it until you're going to get called to the stand. You can also highlight or mark on your report. That's totally fine. If there's a certain part that you think that you're going to need some recall on later on, you can highlight it, you can mark it, you can draw arrows on it. It's all okay. You can make notes on it. But again, they don't want you to read from it. They want you to, if you get to refresh your memory, you'll get a minute to read it, whatever part they're looking at, and then you have to put it down, and then you can testify to it. You don't just get to read it unless the DA wants you to read a specific part. That would be a little bit different. So again, you can mark, you're going to mark evidence, you can mark on your report, same thing. For most cases, especially felony cases or those kind of procedurally difficult misdemeanor cases, it's a good idea to meet with the district attorney. prior to testimony. So, and they're actually really good folks. You can make an appointment with them, and just drop by and talk about the case a little bit. And really, I put in here, don't assume that he or she will know all of the facts of the case, because if you've ever been to court, the dockets a lot of times are full, which means that a lot of the attorneys have a lot of case files. And if you're a prosecutor in a local office, you might have 20 to 30 cases, and you can't possibly know every single piece of those cases. The same would be for a defense attorney. You're not going to know all of those. So it really is a great idea that you meet with the DA first and just kind of go over the case. A lot of times, if it's a homicide case or one of those really difficult felony cases, they may get a message to your department to make the appointment for you, and you'll just sit down and talk about it, about what maybe some questions that he might ask you, or what's the weakest part of your case, or different aspects like that. So just understand that it's not a bad idea to meet with the DA on your case. Matter of fact, it's probably going to make you feel a little bit better. And then as you review your report, think about those really tough or sensitive questions, things that not necessarily will trip you up, but things that are going to be hard to answer. And a lot of times, we don't like to, some of you may not like, I don't want to make a blanket statement, but some of you might be less likely to use profanity than others. But if there's a quote and you have to say it in court, you have to be okay to say that. So just think of little things. There might be some sensitive things if it's a child abuse case or a sexual assault case that you're going to have to testify to, and it could be sensitive and make you feel uncomfortable. But you're going to have to be able to get past that. And then, not just sensitive things, look for the holes in your report that maybe a DA might kind of pick on you a little bit because maybe you didn't ask a couple of questions that you should have. And that happens a lot, so don't panic. You'll be on the stand and you'll figure out, boy, if I just would have asked a couple more questions, that would have been great. And again, if you didn't ask the question, you didn't ask it. But it's good for you to kind of look at your case from the other side and see where you think the defense attorney might, find a little chink in the armor or what have you. So again, when you discuss with the prosecutor, discuss the facts of the case, let the prosecutor know about any concerns that you might have. Like maybe the witness was, okay, but didn't give a great statement, or the ID was just okay, it wasn't really great, whatever those little issues are. And that will really help the DA out on figuring out if maybe they want to do a plea deal or something. So, these are different things that happen because maybe your case isn't super strong, or maybe even the defendant's case isn't that strong. So, talk about those strengths and those weaknesses with the DA to make sure that, you feel comfortable about every single thing. One big thing that a lot of younger officers don't really get kind of out of the gate when they're new, dress professionally. And, that there are times that you're going to want to wear your uniform to testify, and there are times that maybe you don't. Anybody have an idea on why it's like that? Why sometimes would you want to wear your uniform when you testify, and maybe sometimes you may not?
I'm thinking more along the lines of like intimidation. Like there's some cases where you don't want to like intimidate the jury or something because wearing a uniform might be intimidating for certain people. Or like if it was a child's case, maybe they don't want that kind of aspect on the officer.
Okay, and that's a good answer. So yeah, there's a couple of different types of cases that maybe sometimes you just show up in a suit, or something, but not, on the other end, don't show up in jeans, flip-flops, it's either going to be your uniform or something more conservative. For males, a business suit, and conservative colors, if you can. I remember one individual I worked with in Compton. He was a great police officer, but the color of his suits were so bright and so distracting. I mean, and that was what he liked to wear, and sure, that's okay. You can't really, if that's what he wants to wear, that's great. But it can be distracting if you walk in a bright canary yellow suit. Again, I'm not gonna, kind of talk down about the person, but it can be distracting. So, kind of conservative colors if you can help it. Especially for males, not too much jewelry. You don't need the 7 gold chains hanging off your neck or out of your shirt, or whatever. For young ladies, business suit, dress pants, conservative color, same thing. So you're just going to want to present yourself professionally. So the jury, unfortunately, when you talk about juries, they're allowed to, since they're the triers of fact, they are allowed to have an opinion about you. And if they don't like that opinion, then maybe they won't put some weight on your testimony. So that's why you just want to, be professional, act professional, and dress professional to the best of your ability. Let's see. Before court begins, if you've never been in a courtroom, it's always a good idea to kind of peek in. A lot of times the bailiff might let you in. So you want to familiarize yourself with the courtroom layout if you can. So that way you don't walk in, there's a whole, a bunch of people seated there that are, watching the trial. The jury's already there, the judge, everybody's there, and you walk in and you get lost because you don't know where you're at, or you don't know where you need to walk to. Because when they call your case, if you're sitting outside in the hallway, the bailiff is just going to stick his or her head out and say, Officer so-and-so, you're up. And you're going to walk in and everybody's going to be staring at you. So you want to at least know where the witness box is to where you're going to walk to. So you're not just, you don't want someone to have to say, over here, officer. You kind of want to know where that is. So you want to know where people are at, where things are at, etc. So getting there a little bit early and peeking in isn't a bad thing. So that's always a really good idea to do. While you're waiting to be called, be attentive, pay attention to what's going on. If you're in the courtroom, sometimes you can sit in, sometimes you can't, where they will exclude all witnesses and you have to sit in the hallway. So if you're out in the hallway, understand that people around you, you don't know who they are, and you don't know what connection that they have with the case, whether they're alternate jurors. I mean, you just don't know. So a lot of times, people watch you when you're out there in the hallway. So don't geek around. Watch your language. Be professional, whether you're in the courtroom or outside of the courtroom. Pay attention, or be mindful of hallway conversations. Don't say anything in the hallway that you're not going to say on the witness stand. Because again, you don't know the connection that the person might have with the case. And then be mindful of your body language. That's really important because a lot of folks, they kind of newer officers, they might be a little bit nervous, and sometimes they might even joke a little bit, and the juries typically don't like that a lot. So, just kind of understand your body language, sit up straight, face you probably won't be facing the judge. You'll be facing out towards the defense and prosecution table. But if you're asked a question, look at the jury every once in a while. Don't sit there with your head down. Don't do this where you put your hands under your chin and kind of like, hang on the edge of the count, on the table or something like that, or like this, like sometimes we do. Those are like, that body language says I'm not really interested. Try not to fidget. If some of you are fidgeters, where if you're in a swivel chair, don't be rocking back and forth. or doing this where you're kind of going back and forth because the jury's going to be looking at you. And you just want to, it's kind of hard to sit still and not, not be nervous. But if you need to, if you fidget with your hands, put your hands down, so that way people can't see you geeking around with your hands. So again, just watch your body language, and don't, whatever you do, and this is a big one, but a lot of times people don't know that they're doing it. If somebody else answers, or the DA, the defense attorney, asks a question that you don't like or whatever, even if it's accusatory, don't roll your eyes. And a lot of people do that. They don't know they're doing it. They just kind of, like your kids, how they do that and they make that noise, that little huff noise where they go, and they roll their eyes. Yeah, you have to be really careful that you're not sending those kinds of signals. So a lot of us do that eye rolling thing without really kind of knowing that we're doing it. So again, pay attention. The more you do it, it is kind of practice. The more that you do this, the better you'll get at it, where you can kind of just remain sort of neutral looking while you're up there. Doesn't mean you can't smile, but again, you don't want to, come off with a joke or something. So again, you'll either be in the courtroom or outside of the hallway. Typically, if you're an investigating officer, a primary officer on the case, etc., you'll probably be seated in the courtroom, or you might even be next to the prosecuting attorney. So if you're the solo officer that took this robbery report and the suspect was caught, more than likely you're the IO, you're the investigating officer. So you're going to sit there up in front with the prosecutor, because if he has questions, he may want to lean over to you and ask you a question, or write it down on a pad and have you answer it. So that's kind of cool when you're the IO. So that's kind of a neat thing. When you get up on the stand, remember, everybody's looking at you, and they really are. When you get up to, on the witness stand, speak loudly, but don't yell, but be confident. Know how to pronounce names of people, because it sounds a little bit more professional. If the person has kind of a name that's difficult to pronounce, you may want to practice it a few times just before you testify. So that way you kind of, got the hang of how maybe they pronounce their name. So just understand that. Again, think about your body language. And if you're one of those folks that talks with your hands, I tend to do that sometimes, where you kind of talk and your hands are out in front of you and you're kind of moving around. Just watch that, because again, it can be a little bit distracting for the jury. So you want to make sure, to whatever you need to do with your hands, do it, but not to where they're like way out in front of you and you're pointing or talking with your hands or something like that. So, and the first time you actually are sworn in, trust me, if you've never done this before, if you've been a witness to something, then you've had to get up in front of everybody there, and the clerk will walk up to you, or from where you're standing, the clerk will say, raise your right hand. And when you put your hand up, you can watch a lot of new people that testify, their hand shakes, because they're trying to hold it still and they're doing this because you're nervous. It's your first testimony. You're kind of, you think you're really cool and you're up there, and raise your right hand. And right when that hand goes up, man, you start to kind of get the little shaky hand, because they're gonna read this thing to you. Do you swear to tell the truth, the whole truth, nothing but the whole truth, so help you God? And yes, I do. But it's hard to keep your hand still sometimes. So just kind of think about those things too. A lot of times, so some strategy, when you begin your remarks, you're going to face whoever's asking you. So if the defense is asking you a question, you're going to want to look at that person who's asking you the question. You're going to make eye contact with them. When you answer, you can continue to look at that person, or you can turn and face the jury, because the jury wants to know what you're saying as well. They can hear it. There's going to be a microphone up there. So, they're going to be able to hear you. So it's not a big deal. But it's nice every once in a while that you make eye contact with the jurors. So it's just that way they feel comfortable that you're looking at them, and you can answer a question while you're looking at them too, so they can see your face while you're doing it. So also, before you answer, always pause. And I'm not talking about taking a 5-minute break or even a minute. That's way too long, but take a breath before you automatically just blurt out your answer. And there's 2 reasons for that. The first one is that if the prosecution, your counsel, wants to object, they need a second to do that. So if the defense asks a question and you just blurt it out, the prosecutor has no recourse because you've already blurted out the answer. So that's why you just kind of want to take a breath for a second. And the second reason is to think about what you're going to say. So, again, it's not a long pause. It's just kind of a little short pause so you can kind of get your mind right. And I don't know about you, but a lot of times when you get on a roll, sometimes we talk very fast. We just start ripping it off, and it's coming out, and it's really hard for the jury to listen when you're speaking super fast. So just kind of relax a little bit, take the breath, and answer the question, but try to kind of keep it at a speed where everybody can understand what you're saying, so you're not going a little bit too fast. In the courtroom, you'll come across basically 3 different types of testimony. There's direct, cross, and redirect. So don't think that just because you answer questions one time, you're done. The judge will actually excuse you when you're all done. He'll clarify with the 2 attorneys that no one wants to ask any more questions of this witness, which is you. And then the judge will excuse you. Not the district attorney, not the defense attorney. The judge will allow you to leave, and they will tell you when it's time for you to go. But direct testimony is that testimony that typically, that's what starts it off. And this is where your counsel, the prosecutor, is asking the questions. That's considered direct testimony. And a lot of times you'll be asked open-ended questions, and we've talked about different types of questioning. And here's an example that the DA might kind of throw at you for a question. Explain to the court what happened when you first arrived on scene. That's pretty open, and there's a lot that could probably go in there. So that's why you want to take that breath, take a minute, and kind of think about, okay, what's the first thing that I want to say? Because there's a lot there. And you want to break it up into little, into just regular sentences. Don't just ramble on forever, because they're going to stop you. And if whatever answer you give, if it's not enough, the prosecutor will follow up. They'll say, okay, so you said when you got there, you saw this. What else did you see? Oh, okay, I also saw this. So they'll help you along. So don't worry about missing anything. But you're not going to dictate, 3 paragraphs up there on the witness stand all at one time. You're going to do it in little pieces, if that makes sense. And your attorney will help you out. So don't worry about that. They're actually really good about that. So when your attorney, the prosecutor, is all done with you, then we have cross-examination. And this is where opposing counsel gets to ask you questions. And typically, they like to ask you closed-in questions, like yes or no, because they kind of want to trap you into an answer. The big secret with cross-examination or anything, even from the prosecutor, if you don't know something, what's the answer that you give? Yeah, you tell them, I don't know. And that's okay. It's okay not to know. Don't say, well, maybe, well, I don't know. I guess that's not a good answer. If you really don't know, you say, I don't know. And it's no big deal not to know. If it's in your report, the prosecutor will direct you to take a look at page 5 on your report, paragraph 3. And you read that for a second, and then they'll come back and say, now, the question that I asked you a minute ago, do you remember now? And you can say, yes, I do, and then you can give an answer. So again, if you don't know something, you don't know it. Okay. Remember, the objective in cross-examination is to kind of attack your credibility a little bit, or to impeach your testimony, which means find little things that aren't consistent. Okay, it doesn't mean that you're a horrible person, okay, but they want to look for any little, like I said, chink in any little inconsistency. Well, you said it was 10 miles an hour and now you're saying it's 20. Which is it? It's a little inconsistent. So that's kind of what they're looking for. So again, stick to your answer, stick to your guns, take your time, give your answer, and if you don't know, you don't know. Don't guess. Don't say, well, I guess it could be. That's a bad answer. So that's a really important part. And then the good part, though, is that you get what's called redirect. So after your attorney, the prosecutor, asks you questions, and then the defense attorney gets up there and does the cross-examination, if there's anything that needs to be clarified, the prosecutor can do what they call redirect. And this allows you to clarify some previous responses. So maybe they call it damage control, kind of, but maybe you said something that wasn't quite consistent. The prosecutor can come back and say, I want to clarify this one question, and then they can even re-ask it again. So this is kind of where they tighten things up a little bit, because maybe there were a couple of missteps in your testimony. And it happens to the best of us, where sometimes you not necessarily misspeak, but you're not exactly accurate in your testimony, or you say something that kind of is a little bit more of a guess. And here is where the prosecutor can come back around and kind of tighten those loose ends up a little bit. So that's the good part, is we do have redirect. One big thing to remember: if it's not written, it didn't happen. And because it's really hard to convince a jury that if it was that important, why didn't you put it in your report? Doesn't mean that you're going to lose your case or all that other stuff, but they're going to look at it and really find out, why is this piece of information that was so vital, why is it not in your report? So sometimes your attorney can kind of clean that up a little bit, but that's why it's really important to be thorough, to be accurate. Some officers even do a checklist when they're writing a report, but whatever mechanism that helps you, you want to make sure that you use whatever you need that makes your reports more thorough. Because again, the question you're going to get is, well, officer, if this was so important, why did you fail to document it in your report? And the answer of, well, I don't know. I mean, that's not a very good answer. So the jury's going to kind of look down on that answer as well. He doesn't seem very thorough. So you have to kind of understand that. Missing information, however slight, could provide the defense for a reasonable doubt. Because remember, for them to get a not guilty verdict from the jury, they don't have to prove that their client was innocent. All they have to prove or show or make one of the juries believe is that there is some reasonable doubt. And if that reasonable doubt means that one person or two people out of the 12 say the person's not guilty, you're not going to win your case. So, I mean, again, they don't have to prove total innocence. Their whole case, their whole defense might be to show that you didn't meet the elements of the crime. That could actually be a thing. And that has happened before. So again, that's why we want to make sure that we understand all of the elements to our case. So, we kind of already know this. Practice, feedback, practice. They're really the best learning tools to kind of hone your skills, both in testimony and both in writing. If this is new for a lot of you and you haven't done a lot of writing, well, then you're learning. If this is kind of old hat for some of you, then that's okay. But then you want to hone your skills, and the more, it's like anything else. It's like my golf game. I only go out. Typically before the kind of the pandemic, I was like a every 4-month golfer. and I suck. And how can I get any better if I don't go out and do it anymore? It's the same thing, even though that's kind of a weird analogy to put to it. If you don't practice it, you're not going to get any better. The same with speaking in public. If you're not really good at that, you need to kind of get over that. You know, if you have to videotape yourself or talk in front of your friends or whatever it is that you do, you're going to have to learn to get over whatever hurdles, shyness, whatever it is, because this job really does demand that you talk to people and testify in court and all those other things. So again, practice, practice, practice. We talked about telling the truth. There's nothing worth, there's nothing and no reason absolutely to perjure yourself, which means to give false testimony. Okay. Don't embellish. Don't make stuff up. Okay. The facts are the facts, and the stuff that's not a fact won't be a fact. Remember, the jury, they're the ones that get to decide. They're the trier of fact. And even if you may not win every single case. They may say, well, you know, it was okay, but I felt this way, and it kind of the way it is. But you don't want to embellish on anything. You don't want to get caught cutting corners or kind of embellishing on whatever. If the person said something, then that's what they said. If they didn't say it, they didn't say it. You just want to be honest in your testimony. There's nothing worse than getting caught in a even if it's a little fib. Okay, it's going to come back to bite you. So in your reports and in your verbal testimony. So that's a really important thing. We've talked about this case. This is a really, really big case. And if you end up, there's something out there in the policing world that's called the Brady List in California. And it's based on this case, the Brady versus Maryland case, where the prosecutor did not turn over exculpatory information, which means information that could have benefited the defendant. And because of that, this case came out. And if you lie on a report, or if you lie in testifying and they find out, you could be subject to the Brady List depending upon how bad it is, which means that every time you testify in court, the defense attorney can bring up to the jury the fact that you lied before. And you can see that's not a good thing, right? That's just going to be, it's going to be not only stressful, but it's very damaging, to where you go in and before the during closing arguments or something, they can bring up the fact that you're on the Brady List and that you didn't tell the truth in a report. So that's not a good thing. So you just want to be as honest as you can. Don't fudge a report or testimony for anybody or for anything whatsoever. I'm not going to go through the whole case, but there it is if you want to read it. Again, some tips: don't guess. Either you know or you don't. Don't speculate. Speak loudly, speak clearly, don't yell. Listen to the question when they ask you the question. Formulate an answer, and only answer that question. Don't ramble on and answer 3 more questions that were not asked of you. Does that kind of make sense? If they ask you about the color of the car, don't ramble on to stuff. Just give them the answer that they're looking for, that you believe is true because you're testifying honestly. And if you don't know, you don't know. Don't look around the courtroom. Don't stare at the ceiling, because the answer is never in the ceiling or up in the sky. Again, it just kind of is what it is. So whatever, just the one question. And if the defense attorney wants to ask another question, he or she will. But you're just going to ask the one. And if you need them to repeat it, you can say after they ask the question, I didn't understand the entire question. Could you please repeat it? And the judge will tell them to repeat it, which is fine. Or the court clerk will read it back, so you can hear the question again. So if you need to hear it, it's okay to ask. Be polite. Be courteous. If you say yes, sir, yes, ma'am to the prosecutor, you should say yes, sir, yes, ma'am to the defense attorney. Don't snicker at them or, whatever. Don't make a mean face at them. Everybody is the same because this is a fact-finding deal, right? So courteous, polite, act professional. Don't memorize your testimony. Just speak from what you recall. And if you need to recall more, you're going to be able to look at your report. There's no way that they're going to expect you to know every single thing in that report. They're just not. So you're not superhuman, or maybe you are. Maybe you have a photographic memory or something like that. But typically, again, you don't need to memorize everything. Again, just some kind of examples. I mean, when you're up there testifying, watch your hands. Unless you need to describe something, then that's a little bit different. You may have to hold up a photo. A lot of times, the photos will be up on a board. Nowadays, they actually kind of show them up on a projector, so you may not have to do that. You may have to exit the witness stand and walk over to a board and point to something. That's very possible. You may have to point and identify the defendant in court. That's very possible. And if you don't know their name, that's okay. But if they're seated at the defense table, you can point to them and say, that's him or her seated next to the defense attorney wearing the red dress. That's exact, and that'll be how you identify them. So just a lot of different aspects when it comes. Again, sit up straight, keep your hands on your lap, especially if you're a fidgeter. That might help you. Or you can put them on top of the table if you can control yourself. Don't tap. A lot of us tap, and a lot of these witness stands, a lot of if they're old, they're kind of made out of wood, so they're really loud because they have the microphone up there too. So don't tap. Don't take a pen. If you're like me, I'm a pen fidgeter. I do this. I spin my pen around, which drives everybody crazy. So don't bring something with you that is going to cause you to do that. If you make a mistake, own it. If you said something incorrect, it's incorrect. And then the prosecution will come back around and correct it and ask the question for you to clarify. Okay. But you don't, again, if you make a mistake is a mistake. If it's in your report and it's a mistake, then, or you did something procedurally wrong, hey, it is what it is. So just let the facts speak for themselves. And then avoid looking at your attorney or around the courtroom when testifying. Try to focus on one thing. You can start by looking at your attorney because you want to see when they ask you the question. But remember, every once in a while, you want to look over at the jury because they're the ones that are looking at you. And sometimes these courtrooms, the jury's kind of seated maybe far to the right. So you may have to kind of turn your head just a little bit in order to look at them. So that's always, it's good to kind of know where the jury is seated at. Okay, so I wanted to also share with you, which I kind of do every once in a while, the investigative aspects as it relates to courtroom testimony. And just to share a couple of important things. So we've talked about things that could go wrong. Not necessarily for court, but in your report. Remember this rule, the exclusionary rule. Everybody should know what this is. Again, this is the rule that mandates evidence that's obtained from a bad arrest or a bad search or a bad interview or interrogation, that's going to be removed from trial, meaning that you're not going to be able to use it. It doesn't mean you lose your whole case, but you might lose a statement or something. So this is important as it relates to your report, which is then going to reflect in your testimony, because if something gets kind of ruled out, you're not going to be able to talk about it in court. So that's an important part. We know the fruit of the poisonous tree, right? This is the same thing that says basically, if you do an illegal search and that illegal search gives you something that leads you to something else, well, that something else is no good as well. So because the first part was bad. So that's kind of the, anything gained through evidence from an illegal search, unreasonable search, etc., that's going to be negated as well. So these are important things to remember. We talked about the final report in our other little lecture, but this is really the determining factor in whether your case is going to get filed or prosecuted. Not just a good investigation, that's important, okay, but the effectiveness of the entire report, meaning are all the elements there? Are all the statements there? Is there enough evidence there? Was everything obtained lawfully? So there's so much to think about. And again, I say that because I don't want you to get upset when your first report goes to the DA and gets kicked back and you're all miffed about it because maybe you didn't get enough statements from somebody or the DA needs clarification. That stuff happens. It happens to seasoned investigators where they submit something and the DA wants a little bit more because, believe it or not, and I'm most of you probably know this, do you think the DA wants to win their cases? The answer is going to be yes, just like you want to make the arrest and prosecute the case. Well, they want to win. They don't want a loser case. So they're going to take those cases. They're going to look at them thoroughly to make sure that they have a shot at winning. They're not going to prosecute a case that they're not going to be able to win. They're just not. It's not like on TV. Okay. So your report really it has to be able to withstand scrutiny from the judge, from the prosecution, from the defense, maybe even the public, and sometimes the media, because believe it or not, how they get a hold of stuff is kind of impressive. The media does a lot of times get a hold of certain things, and you want it to be able to hold up. Remember, your final report represents facts of a case, a criminal history of the person charged, the type of evidence, the names of those who can support the evidence by testimony in court, names of people the prosecutor can talk to for further information, and that chronological sequence of that investigation. So that's the importance of, having your final report in order to the best you can write it in order. Because if it's out of order, it's going to make it really difficult for the prosecutor to follow it. I'm not going to spend a lot of time on this because we've already kind of covered this. But this particular lecture talks about, the different headings that we've talked about. And again, they're a little different here and there. So I'll kind of go through all that. Note that some of your reports, though, you're going to have some laboratory reports that'll come back. So if you arrest somebody for DUI, there's going to be a blood alcohol report. If you have some drugs that had to be analyzed, there's going to be the report of whether or not that's actually heroin, cocaine, methamphetamine, marijuana, whatever. There might be photos, sketches, drawings. We've kind of talked a lot about all that stuff. So it's not just your narrative. There's a lot of other little attachments and things that kind of go together, that all come together to make that report. And I made a little notation that the quality of the content and the writing does help influence its credibility. The lesser the mistakes in the report, the more credible it is. And maybe that seems wrong, but that's really the truth. If people don't find a lot of errors, they know that you took the time to proofread, and it's a little bit more credible. But if there's a lot of mistakes in the report, people tend to see that as less credible. It doesn't have to be fair. I'm just kind of giving you how people view things. We'll skip past this here. We've already talked about sketches. We've talked a little bit about what we call exculpatory evidence. Remember, during your investigation, if you find evidence that might benefit the defense, you have to turn it over. Don't hide it. You can go through the attorney, through the DA's office, but you're going to want to write that in if you have a statement that actually exonerates the person, then you want to write that in your report. Because your job isn't necessarily just to arrest and convict that person. It's to find the truth, the facts of what it is. And if the facts if the facts show this person didn't do it, then that's the fact. And that's part of your job, is to make sure that you do that. And we've talked again about clearly, accurately writing your report, that logical sequence. Most people know what the role of the prosecutor is, so I won't spend a lot of time on that. But they are the ones, just so you know, the prosecutor, not the judge, not you. The prosecutor decides what cases are filed. And there's no way to go around that. So that's why sometimes if you have a case that maybe isn't that great, you may want to meet with the prosecutor and tell them, here's what I got, and show them this and that. And they may ask you, we'll do a little bit more follow-up and then I'll file the case. But they're the ones that get to decide whether or not the case is filed, not you. Now, you can go argue your point. You can go to their office, like I said, and say, hey, prosecutor, this is a good case. I'd like you to read it and look at it and tell me. And if they like it, great. But if they don't and they need more info, then that's what they're going to tell you. Okay? They have a lot of discretion and they have a lot of power. Matter of fact, they're one of the more powerful individuals in the court system because they have the ability to turn a case down, to ask for more follow-up, or to file a case and to prosecute a case. The judge doesn't have that authority. The judge is the trier of law. The jury, they're the trier of facts. They get to determine guilt or innocence. But the prosecutor really is the one that starts the ball rolling when they basically file your case or not file your case. Okay? Some reasons that maybe your report doesn't get filed, that maybe the complaint is invalid, meaning really it wasn't a valid complaint. Sometimes you'll see that every once in a while in maybe an assault call where you get there and somebody might say that someone hit someone, but it really didn't happen. So, I mean, that happens every once in a while. So if you have an invalid complaint, again, the prosecutor might decline after they look at the report. They might want more information. This happens often too. The complainant doesn't want to prosecute. Anybody know in that particular situation what crime typically fits in there, where we see a lot of it where the victims don't want to prosecute?
Isn't it like domestic abuse?
You get a lot of that where it could be the male or the female, but because there's still a relationship there, etc., how bad it might be still, that a lot of times one person may not want to prosecute. And a lot of times it's the woman that doesn't want to. Now, under some domestic violence laws, the state can actually prosecute. But a lot of times people drop the case. I won't testify. I don't want to do anything. I don't want to say anything. A lot of times in gang-related activities, one gang member does a drive-by on another group, someone gets shot, nobody dies, so we'll handle it ourselves. Is kind of how they do it sometimes. So you might have something where the offender, the suspect, passes away. So it's hard you can't prosecute somebody really when they're not there anymore. So that could be a reason for that. The offender is in prison or out of the country where they can't be returned, or no evidence or no leads, not enough evidence. And sometimes there are cases that you just don't have enough evidence to file. Maybe you have a statement, but you don't have any physical evidence to back up the statement. So again, these are just some of the reasons that maybe your case doesn't make it to trial. We talked a little bit about how preparing a case. Again, once a decision is made to prosecute a case, more than probable cause is now required. Probable cause is what you need to arrest. But now that bar goes up higher and we have to reach the beyond a reasonable doubt level. So if the DA wants a conviction, that bar goes higher now and we're at that beyond a reasonable doubt. And that's what you need for a conviction. So that's what you're looking for. So that's why it's important that your report is thorough. And, when you talk about preparing your case, that means like reviewing the evidence, looking at your evidence sheet, reviewing it, make sure that everything is the way it should be. And let me tell you a very quick little story, and I won't take a long time because we're a little ahead of schedule, but the importance of checking your evidence sheet or not checking it. So I was working in the gang unit, and we had made a fairly decent narcotics arrest. I think it was like a pound of cocaine or something like that. I'm trying to remember the exact amount, but let's just go with a pound for the weight. And it was all booked. I photographed it. I weighed it in front of witnesses, and it was all booked away and everything was great. So I send it over to the lab to get analyzed. And on the date of the hearing, I don't have to bring the actual drugs to court, but I do, and I bring the little analysis sheet, because from the lab you get a little sheet. So I bring the drugs and I have the analysis sheet, and I'm up there and I'm testifying, and I talk about how the evidence was found and seized, and the DA instructs me to open up the envelope and remove the drugs from inside because they're in like a big baggie. And when I lift it out and I look at the weight of the drugs on the little analysis sheet, half of it's gone. And I'm on the witness stand, and I'm like, and I'm trying to think, okay, what do I do? How do I say this? Because they goes, did you weigh that and mark it? Yes, I did. And the total weight was, whatever it was. And I'm thinking to myself, no. So I had to kind of, excuse me, there's a problem. We had a little sidebar and found out that we actually had a clerk that stole part of it, that took it to the, So see the importance of reading your stuff before you go to court. If I would have looked at that sheet before I went to court, I would have went, something's wrong. And I could have ran to the sergeant, who could have ran to the property person, and we could have maybe figured it out before I was on the witness stand testifying, and then half my stuff is gone. Yeah. So, I was stressed out. But it all got taken care of. They all figured it out. Everything ended up the way that it should, but that shows you the value of looking at your report before you go to testify. So I learned a really big lesson. So again, review your evidence, evaluate the evidence, make sure it's what it is. Look at all your reports. You may not prepare your witnesses, but the DA sometimes on a big case will. They'll talk to the witnesses to make sure they know what's going to be said. You're going to write your final report. And the pretrial conference, that's you meeting with the DA. That's all that is, where you sit with the DA and talk about your case. So these are all kind of little things to do. And we won't go through each one of these. We already talked about review the evidence. Again, make sure that it was booked properly, that you have what it says it is, so you don't end up like me. And you're missing, half of your, half a pound of dope or something like that. That doesn't look good on the stand. I laughed about it later, but it wasn't funny when I was up there. We already talked about Brady. We talked about reviewing reports. I just want to make sure that we kind of get through all of this. Let's see. I think everything is pretty good. We talk about preparing witnesses. You may sometimes be asked by the DA to re-interview witnesses, but a lot of times you won't. They'll be subpoenaed to court. They'll come and testify just like you are subpoenaed to court, and you will testify. But sometimes the DA will actually sit with the witnesses just to make sure that what they say or what they said was very similar to what's in your report. So, that's important. Let's see. We already know so if you've never kind of seen how a case moves through the system, whether it's you've got your investigation of your incident, you have the kind of the charging stage, whether we're going to charge someone or not. And then here it's going to be that's where all the motions happen. A lot of times, even before your case gets to court, there's a bunch of motions that the defense will file. The officer illegally seized the evidence. The officer intimidated my client. It wasn't my client. All these little things are done beforehand. But after it kind of makes its way through the system, it's going to end up right here. And you're either going to do a jury trial, a bench trial, which is just a judge. There's no jury. A plea bargain, which happens like 90 to 96% of the time, depending upon what state you're on. Or sometimes people actually plead guilty. They just enter a guilty plea. But typically, it's because of a plea bargain. Most people don't just walk up there and go, yep, I'm guilty. I'll take whatever I get. A lot of times there's a little deal that's going to be made through that plea bargain there. So we already talked about this. Your final prep, look at your stuff, dress appropriate, be on time, don't be late. I mean, it's different if you're on call and you're in the field and you're handling a call and they call you and say, hey, you're supposed to be in court right now. They're waiting for you. Okay. They know it's going to take you a minute to drive from point A to point B and get there and all that stuff like that. But if you're supposed to be there at 9 o'clock, be there at 9 o'clock or a little bit earlier. I would recommend just so they're not waiting on you. All right, we know what a trial is. Remember, when you talk about the main participants for a trial, judge and the jury. Okay, these are, when it comes to that, a lot of times there's legal counsel, there's defendants, witnesses. These are all the kind of different players that are in there. The judge or the magistrate is the one that presides over the trial. Remember, they're the trier of law. They don't if it's a jury trial, the judge does not determine guilt or innocence. They deal with motions, objections, procedural things. They keep order and they interpret the law. Okay, they pass sentence, of course, but they're not going to determine guilt or innocence. They will in a bench trial, but not in a jury trial. So just kind of understand. The jury in a jury trial, they're the fact finders. Based on what the prosecutor and the defense let them see, whatever their evidence is, etc. All the factors are kind of come into play. They're the trier of fact, not law. So they determine the guilt or innocence. But understand this: the jury, they are allowed to, and as bad as this kind of sounds, because they're the trier of fact, they don't have to believe you. And it can be based on whatever they think. If they don't like your hairdo for the day, and or the way you smirk, or the way you dress, or how you talk, it's not fair, but it's the truth. Meaning that they can hold that against you, basically. So again, that's why you just want to be very even keel, professional, and not give the jury any ammo to kind of not like you, if that makes any sense. So that's why we talk a lot about that. All right, we already know the definitions of all of these different things. We talked about without a jury is a bench trial, in front of a jury is a jury trial. Jury selection, we don't have to go through all that. We talked about waiting to testify. Don't talk in the hallway. You just don't know who you're going to be talking to. So it could be a relative, it could be a defendant. I mean, you just don't know. Could be another attorney representing somebody else. So you don't want to talk about your case, etc., and things like that. Let's see. Testifying, we already talked about this. Speak clearly, firmly, answer the questions directly. Don't volunteer things. Just answer what they're asking you. Remember to pause. You can refer to your notes if you don't remember exactly. And again, it's okay to say, I don't remember. I don't know. I don't remember. That's totally okay. Be calm about it. When you don't know an answer to something, admit your mistakes, like we've talked about. Don't use codes. We talked about police jargon. Don't use 10 codes, 9 codes, different words, the lingo that law enforcement tends to use. Don't be sarcastic. I've seen officers that can kind of get away with a little humor. It's okay to smile, but you're not up there doing a stand-up comedy routine. Okay, it's very serious, and again, you just want them to take you serious. Tell the truth as you believe it to be, as you know it, and everything will be fine. But again, if you don't know, you don't know. Remember your nonverbal stuff. Your eye contact, your posture, your gestures, your mannerisms, your rate of speech, your tone of voice, even your facial expressions. If you look at this picture, she don't look like she kind of looks angry, I guess, or not interested, or not really sure. And I know it's hard. You're not a robot, so you're not just going to be able to sit there. And you can smile and things like that. But again, just try to keep a handle on, your nonverbal factors. Understand that, when you look at nonverbal stuff, what is said typically is about 7% of the message. How you say it's about 38%, and all the nonverbal stuff, it's about 55. So nonverbal really is important to remember, and how you say it. So don't be snippy, don't be snarky, don't be mean. Yes, ma'am. Yes, sir. No, ma'am. No, sir. For both attorneys or anybody else asking you questions. If you just keep it that way, then everybody gets treated the same way. Okay. Let's see. Talked about objections. Just make sure that when you answer a question, just give it a little pause, like we talked about. So that way, if somebody has an objection, they can jump in there and do that. When you're done, we're all done with testimony. Don't just get up and leave, because the judge is going to kind of get on you a little bit. Okay, so you don't leave and you don't stand to leave until you're told. And again, typically the judge will say, does anybody else, and he's talking to the attorneys, are there any further questions for this witness? And they'll both say no, and the judge will look at you and say, Officer so-and-so, you're excused. And that means now you can get up and you can leave. You can return to your seat in the courtroom if you're allowed to be in the courtroom, or you can just leave the room and go back out in the hallway. Or you can leave and go back to the station if that's where you're going to once you're all done. Don't take the outcome of your case personally. Don't get pissy about it. You're going to win some and you're going to lose some. And it's all kind of a learning experience. Okay. So again, you can't really get angry. All you can do is make sure that maybe look at your case afterwards and kind of see, well, where were the holes at? What happened? Well, the witnesses weren't as good as we thought they'd be, or the evidence wasn't as good, whatever it is, and you can just do better next time. So there's no scorecard out there. They don't keep a scorecard out there that says, oh, look, it's the officer that never wins. That doesn't happen. Okay. So again, it's not a contest, but you definitely want to do as good as you can. Okay, I think we're about there. All right, so that kind of takes us through the kind of the final pieces, if you will, of the reporting process and court, and the importance of making sure that we meet the elements to whatever crime we're investigating, that we write things in that chronological order, that we're using the headings that we've been taught to use. And again, when you get a little bit better at report writing, you don't want a shortcut. Okay. And it's really easy for all of us to take the easy way out and say, well, this report, it's a burglary, so it's probably a half pager. Write it as you need to write it, hoping that maybe a suspect might get identified and later arrested. And then when they pull your report for the crime, it's more than a paragraph long. Does that make sense to everybody? Yeah, you want to be able to write that so if they actually catch if you write a really thin report with no info and you're just kind of cutting corners, it's 5 o'clock and shift ends at 6 and you want to get home and you write this really, kind of report that's not very thorough. When they catch that guy tomorrow and they pull your report, they may not have enough to file a case because your report isn't good enough. So, I mean, and it happens that way where you might write this report now and 2 weeks later, the suspect's in custody. And then they look at your report. So you want to write that report as if it's going to go to court and somebody might be held responsible for it. And if they are, this report is going to be bomb, and it's going to do what it needs to do in order to get a filing and hopefully, put this person, hold them responsible for whatever they did. So hopefully that kind of makes a little bit of sense to everybody. So with that said, any questions on tonight's lecture? Fairly straightforward. Any questions on anything else? Everybody's just wonderful. I think you're wonderful. So, okay, whatever. All right. So I'll have office hours tomorrow. They're going to change tomorrow just a little bit. So maybe 5:30, but I'll send something out in the afternoon. So it might be 5:30 to 6:30. If it stays the same, if it's from 6 to 7, I'll let you know. But either way, I'll send something out and let everybody know that I do have office hours still. The time might change tomorrow, but I'm around if you need assistance on anything else. Make sure you're checking your due dates so you know when stuff is due. So we don't kind of let it lapse over too much, and then keep working on your final report because we're getting closer. And if nobody has anything else, then you are done for tonight.
Professor.